Good day to Dr. Junani. We are from Group 2 and today we would like to present about case study Bank Pembangunan Malaysia Berhad versus Ibu Kota Realty Sendirian Berhad and Loh Chia Hong.
Is Nafra and Binti Baharu, matrix number 288348. I will present the background facts of this case. This case features Bank Pembangunan Malaysia Berhad as the plaintiff, Ibu Kota Realty Sendirian Berhad and Loh Chiak Hong as the defendants, and Ibu Kota Daktai Iron Pipe Industry Sendirian Berhad as the borrower. The court issues involve the plaintiff extending loan facilities to the borrower, which were guaranteed by the defendants. Following the borrower's default, the plaintiff sought legal action to enforce these guarantees, leading to the summary judgment in favor of the plaintiff. So the plaintiff provide two main types of facilities. The borrower secured a term loan of up to 75 million to finance machinery and equipment for a project to manufacture ductile iron pipes. The loan interest terms include a 2% per annum rate and monthly payments. The second facility, totaling 55.48 million, includes three sub-facility, which are Term Loan 1 for plant machinery and equipment, Term Loan 2 for TNB power substation, and a revolving credit for raw materials. The interest rate is the bank's effective cost of funds plus 1.75 per annum. So the defendants executes various documents to secure these two facilities, including letters of offers, a term loan agreement, a debenture, and assignment of performance bond. Additionally, Ibu Kota Realty Sendirian Berhad also provide a corporate guarantee and a memorandum of deposit of shares to further secure the loan and facilities. So in conclusions, the case highlights the significance of having robust security documents and guarantees in loan agreements to protect the lender's interests. That's all from me. Thank you.
Assalamualaikum, my name is Nur Syafiqah Wahidah binti Azizia Aswariza, number matric 288265. Today I would like to present about what were the issues raised by defendant. Okay, the first one, in the case between Bank Pembangunan Malaysia Berhad and Ibu Kota Realty Sendirian Berhad with Loh Chiak Hong, the defendant agree on multiple fronts to defend themselves. They question the financial claims made against them, dispute the validity of the loan agreement, accuse the plaintiff of wrongdoing, and make sure the legal process was fair. Okay, and I would like to highlight the defendant defense strategy, which is the first one, disputing financial claims. The defendant challenged the accuracy of the financial claim brought by Bank Pembangunan Malaysia Berhad, citing discrepancy in accounting and documentation. The second one is questioning a loan agreement validity. They raised concerns about the validity and enforceability of the loan agreement, alleging procedural irregularity and potential mispresentation by the plaintiff. The third one is asserting counter claim. The defendant filed counter claims against the plaintiff, accusing them of breaches of duty or contractual obligation, which they agree should offset their liability. And the last one is ensuring procedural fairness. They emphasize procedural fairness, raising objectives about improper service of court documents, jurisdictional issues, and compliance with legal requirements during the litigation process.
A guarantee is a contract where a guarantor agrees to pay a borrower's debt if they default. In this case, the defendant acts as a guarantor for the plaintiff's loan facilities to the borrower. The defendants guaranteed the full repayment of the loans in case of the borrower's default. The guarantee agreements were properly executed with clear terms outlining the lender's right and the guarantee's duties. This determined the enforceability of the guarantees. The plaintiff was entitled to enforce the guarantees when the borrower defaulted on the loan facilities. As guarantors, the defendants are responsible for satisfying the borrower's debt obligations in the event of default. The court rejected the defendant's defense and affirmed that the guarantees were valid and enforceable. The court's ruling highlighted that the defendants were jointly and severally liable for the outstanding debt. This case emphasizes the importance of understanding and complying with guarantee agreements as well as the obligations of guarantors when providing guarantees for lending facilities. So, the answer to the question is yes.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nushrada Bita Plaza and the number is 2864. Okay, today I will explain about the question number 4, which is, do the defendant have the right to contempt plaintiff when the plaintiff failed to inform the defendant on the change of rate which they claim that the change of were outside of their knowledge and consent? Give your opinion. Okay, for my opinion, the defendant do not have right to contempt the plaintiff. It is because the defendant have been informed by the plaintiff about the initial change in the ECOF rates. Okay, specifically, the notice dated 2 September 2016 informed the borrower that the base lending rate effective 1 September 2016 was 6.75% per annum, which is equivalent to plaintiff ECOF rate. And secondly, the right to vary the interest rate, which is ECOF rate, was stipulated in the security document agreed by the borrower and the plaintiff. Specifically, these rights were outlined in the facility agreement for both the first and second facility. Given this point, the defendant do not have a strong position to claim they were uninformed about the rate change.
My name is Lai Wei Jun, matric number 294145. Next, I will explain the type of guarantee for dependent 1 and dependent 2 and their liability as principal debtors. So, the types of guarantee for dependent 1 and dependent 2 is quite similar. So, the first is the nature of guarantee. Dependent 1 and dependent 2 are structured as the principal debtors and not only for secondary assurance. So, both dependents will need to have the same responsibility like the borrower, which is have the primary liable for debts. So, the second point is joint and several liabilities. Guarantor will be take the responsibility for the entire debts if the borrower defaults. So, bank can claim back the full amount of the loans either from dependent 1 or dependent 2 or both of them flexibility. So, the third point is unconditional nature. Guarantor with any rights to dispute the enforcement of the guarantee on the ground of certain defense that might have been available to the borrower. Next, liability of dependent 1 and dependent 2 as principal debtors. So the first liability is direct liability. The dependent 1 and dependent 2 have direct obligation to repay for the debts and not only serving as a backup. So if the borrower default, the bank can immediately seek the repayment from both of them, but not pursuing the borrower first. So the second is waiver of defense. The dependent 1 and dependent 2 as a principal debtor with many of defense that might otherwise be available to sureties by agreeing the terms as principal debtors. This waiver of defense make it more difficult for the guarantor to contest their liability in court. So the last point is additional protection for the lender. The guarantee agreement state that statement of indebtedness provided by lender are binding unless there was a clearly error. So, any agreement or arrangement among lender and borrower are unknown to guarantor, but it does not affect guarantees. That's all from us. Thank you.